The opposing counsel used the phrase above the law, saying that an immunity doctrine for criminal immunity would place the president above the law. I would just direct the court's attention to what the Supreme Court said in Nixon against Fitzgerald in the context of civil immunity. They described the allegation that immunity sets the official above the law as, quote, rhetorically chilling but wholly unjustified.
In today's hearing, Donald Trump's legal team made several references to another former president, Richard Nixon, specifically a 1982 Supreme Court case where Nixon was personally sued by a Defense Department whistleblower who claimed he was wrongfully terminated. The court ruled in Nixon's favor, stating that a former president is immune from lawsuits and in civil cases, and that such immunity extends to all acts within the outer perimeter of his duties of office. The ruling did not, however, mention criminal charges, nor how overturning a Democratic election so they can stay in office forever counts as any part of the perimeters of a president's official duty. Meanwhile, the special counsel also cited Nixon, although a completely different case, to bolster their argument, referencing U.S. versus Nixon, the 1974 Supreme Court decision that forced the president to comply with a criminal subpoena for his White House tapes in the Watergate scandal. Joining me now is Paul Butler, former federal prosecutor and MSNBC legal analyst, Mary McCord, former acting assistant attorney general for national security and co-host of the Prosecuting Donald Trump podcast, and Nick Ackerman, former Watergate assistant special prosecutor. And Nick, I am going to start with you since we did make a Nixon reference. What did you make of the dual uses of Richard Nixon's former cases by the counsel for Jack Smith's office and the counsel for Trump?
Well, it's just amazing how much Richard Nixon is still haunting us after all these years, 50 years since Richard Nixon. But I think it's pretty clear this whole business about immunity is really total nonsense. If you go back to the 1974 opinion where the Supreme Court unanimously ordered Richard Nixon to produce his tapes, it's pretty clear throughout that the Supreme Court is basing that ruling on the notion that the president is not above the law, that the president has to answer the same in the criminal system as any other citizen. In fact, just recently, the 11th Circuit, in the case overruling the judge in Southern Florida on the classified documents case, made it quite clear that Donald Trump has to be treated just like any other defendant in the criminal system facing charges in federal court. So it seems to me that we've got a whole different situation with respect to a criminal charge. And when you come right down to it, this case has one and only one purpose for Donald Trump, and that is to try and delay his day of reckoning and try to keep from having a jury decide his guilt. It's darn well that once a jury is selected and once the witnesses start testifying, including his own vice president, who's going to testify against him, his lawyers that were in the White House are going to testify against him, that at that point, he is completely gone and he's on the way to the big house. He knows that, and that's why he's trying to delay this as much as possible.
Mary, I have to, since you did work in the national security realm as a prosecutor, get your take and your response to Mr. Sauer's argument that a president could steal national security secrets, check, Donald Trump did that, could sell pardons, and could use SEAL Team 6 to murder their political opponents, or arguably any American they wanted or anyone they wanted, and not be subject to prosecution ever, ever, ever.
I think that's fundamentally nothing that the framers could have ever expected or anticipated. It's true that a president does have substantial sort of leeway to engage in national security and foreign affairs under the Constitution, but that is not leeway to commit crimes such as abusing and misusing the military for political purposes or to commit murder. And I think the Nixon cases that were cited show also the important distinction between civil cases for money damages, like the Nixon versus Fitzgerald case, and criminal cases like the case that the special counsel back then was investigating and prosecuting against the Watergate burglars. The court made clear that there is a need for a president when in office to be able to make decisions without constantly worrying about being sued civilly for money damages. And that's why in Nixon versus Fitzgerald, the court held that in view of the special nature of the president's duties, it's appropriate to recognize absolute immunity for acts that the president engages in within the outer perimeter of his official duties. But in marked contrast to that, the Supreme Court rejected absolute immunity for Nixon complying with a subpoena to provide tapes that he had, White House tapes, as that had been subpoenaed as evidence in that criminal prosecution. And what the court said there, and I'm going to look over here to read it exactly, is that neither the doctrine of separation of powers nor the need for confidentiality of high-level communications without more can sustain an absolute unqualified presidential privilege of immunity from judicial process in all circumstances. So the court, I think, made this distinction, and the dramatic questions that Judge Pan asked today about ordering SEAL Team 6 to murder a political opponent, I think really illustrate why there can't possibly be that kind of immunity. It's nothing our framers would have ever expected. It's nothing that should be countenanced under our Constitution.
Yeah, I mean, Paul, we were treated to everything from, should George W. Bush be able to be prosecuted for lying about the cause of going to war in Iraq? Should, Barack Obama be prosecuted for dropping drones strikes? The Clinton case was brought up that he was, spared prosecution for lying about Monica Lewinsky, et cetera, et cetera, et cetera. But when I'm listening to it, I think of the immunity thing. I think about the police immunity, where they have this broad immunity to kill. But if a police officer goes home and kills his wife, that immunity ends there. They don't have a broad immunity to just go kill anybody they want, kill their neighbor because their dog was barking. They suddenly can be prosecuted. And even in some cases, like with the George Floyd killers, they can be prosecuted even when they're acting in their official capacity.
That's exactly right. And that's based on a doctrine called statutory immunity, which the Supreme Court made up, as opposed to the impeachment, which is part of the Constitution. And so Trump's argument that he can't be prosecuted unless he's first impeached by the House and then convicted by the Senate, it goes against the text of the Constitution. It really flips that argument on its head. The text says that if a president is impeached by the House and then convicted by the Senate, that's the most that the Senate can do to him. Right. But then goes on to say that he or she can be prosecuted in a court of law for a crime. It also goes against the constitutional design, the whole point of separation of powers. Right. And so the president doesn't have this absolute immunity. And finally, Joy, it goes against history. We could talk about another Nixon incident. Remember, then President Ford pardoned Richard Nixon. He pardoned him because there was never an understanding that a former president couldn't be prosecuted. Nixon was pardoned precisely to save him from a criminal prosecution.
Right. And Nick, that I think is a key point, right? Because a pardon implies guilt. It implies that you did the crime and therefore you're being pardoned for your criminal acts. Nixon did famously say when a president does it, it's not illegal. But that wasn't even true for him. And by the way, no president who's been impeached was ever convicted, has ever been convicted. So you'd almost have zero chance of being prosecuted if you become president. It's for you, Nick.
Oh, yeah, no, that's absolutely correct. It just is a totally different system. The impeachment proceeding is a purely civil matter to remove somebody from office. That's all it is. They're just deciding whether he's committed high crimes and misdemeanors and whether there's a basis to remove him from office. That's totally separate from a criminal proceeding. Even the example that was given today actually was probably one of the best examples that was given by the government with respect to Watergate, where Richard Nixon, in his official capacity, was calling the CIA or having his chief assistant call the CIA in order to call the FBI to get them to stop the investigation into the Watergate burglars that would have led to the White House. Those were all official acts, as Donald Trump would phrase it, but that is the key tape. That tape with Richard Nixon and his aides talking about doing those official acts is what resulted in him resigning at the end of the day. And it certainly would have resulted in him being convicted of various serious crimes, including obstruction of justice. We were prepared throughout that prosecution and that investigation to indict Richard Nixon. The only reason we did not indict him was because the House was actively looking at impeachment. We were simply holding back to let the House do its thing, and our plan was to move in afterwards. And within a couple weeks after Richard Nixon resigned, he was pardoned by Gerald Ford.
Yep. And that's the
you didn't
only
see-
reason.
I don't need that pardon.
Yeah.
You know, I've got immunity. That didn't happen.
Yeah. And otherwise, he would have been prosecuted just like Donald Trump is being prosecuted.